and welcome to a new episode of Legal Wrangle on corporate laws. Today we have selected three very important orders, including the one which has been hogging headlines for the past few weeks. Yes, it is the Unitech Limited case which took an interesting turn on December 8 when the Union of India moved the NCLT and got an order to replace all the 10 directors of the real estate company. This order predictably provoked the company management to move the apex court which was seized of the matter. Let's go straight to this case to know more about what the Supreme Court of India had to say. Unitech Limited is a well-known name in the real estate sector. Unitech was engaged into construction of various housing projects. There were thousands of home buyers who had made substantial payments to the company for the purchase of flats in the various projects, but construction did not commence at many places. Unitech owed a huge sum to the home buyers. There were apprehensions about the other irregularities also, which were investigated. In this case, the interests of home buyers, shareholders and depositors were found to be at great risk. The Union of India filed a petition under Section 241 of the Companies Act 2013, which allowed the government to apply to the NCLT if it felt that a company was operating in the manner prejudicial to public interest. The NCLT observed that there was a prima facie case that the affairs of the Unitech were not being carried out honestly and passed an order dismissing the board of Unitech and permitted the government to nominate 10 directors to the board. The NCLT also restrained directors of Unitech from alienating, mortgaging, creating charge or lien or interest in the properties owned by them personally or that of the company till investigation into alleged siphoning and diversion of money was concluded. Unitech moved the apex court against the NCLT order and the order was stayed. The Supreme Court expressed its unhappiness about the manner in which NCLT passed the order without giving any hearing to the company management. Let's move on to our second case. In the case of Rose Valley Hotels and Entertainment Limited, the issue was whether company was operating investment plan under the garb of selling holiday plan. If contributions raised from the public in the form of monthly installments were ultimately repaid to their subscribers as annuities of various interest rates by pooling contributions. Let's understand the factual matrix. The Securities and Exchange Board of India, vide an ex parte interim order cum show cause notice, had prima facie observed that Rose Valley Hotels and its directors were illegally mobilizing funds from the public through schemes in the nature of collective investment schemes without obtaining certificate of registration from SEBI and thereby contravened SEBI provisions. Prior to passing of the interim order, SEBI received a letter from the Additional Director General of Police Bureau of Investigation, Assam, regarding the raising of funds by Rose Valley Hotels and Entertainment Limited and Rose Valley Real Estate Constructions Limited. These companies were stated to have collectively raised Rs 1,000 crores from the public till February 2012. Further, Rose Valley Hotels were stated to have launched a scheme titled Rose Valley Holiday Membership Plan in the year 2010. But according to Rose Valley Hotels, it was in timeshare business which did not come under the purview and jurisdiction of SEBI. Thus, the above mentioned information was not provided to SEBI. In order to protect the interest of investors and to ensure that only legitimate investment activities are carried on by Rose Valley Hotels and no investor are defrauded, SEBI, vide interim order cum show cause notice, issued directions against Rose Valley Hotels and its directors for preventing them from further carrying on with the fund mobilizing activity by launching collective investment scheme without registration from SEBI. The interim order came into force with immediate effect. An opportunity of personal hearing was granted to the company and its directors. SEBI held that Rose Valley Hotels and its directors had contravened the provisions of SEBI Act and CIS regulations by floating collective investment schemes without obtaining registration from SEBI. Let's understand how. On perusal of the balance sheet filled by the company for financial year 2012-13, an amount of around Rs 5,000 crore was reflected under other current liabilities, refundable liability under membership plan. Rose Valley Hotels had submitted that it was in timeshare business and therefore would not come under SEBI's purview. On this ground, Rose Valley Hotels has refused to submit documents in respect of Rose Valley Holiday Membership Plan to SEBI. On an examination of the material available on record, it was prima facie observed that notice company operators investment plan under the garb of selling holiday packages through the holiday plan offered to the public. The contributions raised from the public in the form of monthly installments towards the holiday schemes were ultimately repaid to the subscribers as annuities of varying interest rates by pooling the contributions. The annualized interest, that is, payment on maturity in lieu of the package, made the schemes attractive and lured the public to invest in them. The contributors, the public, had no control over the scheme plans or activities of notice company. To launch or carry on the activity of CIS and mobilize public funds from such schemes, it is mandatory under the law to obtain a certificate of registration from SEBI. SEBI noted that features of the holiday membership plan offered by Rose Valley Hotels qualifies the mandate of a collective investment scheme. Hence, the scheme offered by the notices with the promise of return or annuities satisfies the conditions specified in the section 11AA of the SEBI Act and therefore qualify as collective investment scheme. In a nutshell, the SEBI held that activity of fund mobilization by company with the resultant promise of returns clearly falls within the ambit of collective investment schemes as defined in section 11AA of the SEBI Act 1992. This case relates to Competition Act 2002. The key issue was whether the governing body of a sport can be alleged to have abused dominant position where it used its position as nodal regulator of all aspects of such a sport to create barriers to entry of media players in securing broadcasting rights for such sports. Let's first understand the factual matrix. The Commission had passed an order dated 8 Feb 2013 under Section 27 of the Act, wherein the opposite party was the BCCI, and in said order, the Commission had found the BCCI to have abused its dominant position in contravention of Section 4 of the Act. The BCCI appealed against such order before the Competition Appellate Tribunal, who set aside the order of the Commission on the ground of abuse of dominant position. The Appellate Tribunal remitted the matter back to the Commission for de novo adjudication. Pursuant to such directions, the Commission directed the DG to launch a fresh investigation in the matter in accordance with the directions of the Appellate Tribunal. In the original proceedings, the Commission had found the BCCI dominant in the market for organization of private professional cricket leagues events in India, and that the BCCI exercised regulatory powers for arriving at a commercial agreement. The Commission had found such conduct of the BCCI to be in contravention of Section 4 of the Act. The Commission imposed a fine of over Rs 52 crore on the Board of Control for Cricket in India for anti-competitive practices with respect to Indian Premier League IPL media rights. The Commission found that BCCI enjoyed a dominant position in the market for organization of professional domestic cricket league or events in India. Based on the nature of activities performed, BCCI was held as the enterprise and thus it came under the purview of Competition Act 2002. While recognizing the role of sports federation in taking measures to serve the integrity or development of the sports, Commission noted that the restriction had no nexus to the legitimate interest of cricket in the country. Rather, it was pursued to be enhancing the commercial interest of the bidders of IPL broadcasting rights, and the consideration in turn received by the BCCI hence held to be in contravention of Section 4(1) read with Section 4(2)(c). The Commission directed that BCCI shall cease and desist from indulging in the conduct that is found to be in contravention of Section 4. BCCI shall not place blanket restriction on organization of professional domestic cricket league or events by non-members. BCCI shall issue appropriate clarification regarding the rules applicable for the organization of professional domestic cricket leagues or events in India, either by the members of BCCI or by the third parties, as well as the parameters based on which the applications can be made and would be considered. Besides, BCCI shall take all possible measures to ensure the competition is not impeded while preserving the objective of development of cricket in the country. With this, we wrap up this episode of Legal Wrangle. Keep watching TILTube for our upcoming videos. Please send in your suggestions at editor@tiol.in. Thank you for watching.